But remember, Donald started his career back in 1973 being sued by the Justice Department for racial discrimination because he would not rent apartments in one of his developments to African Americans, and he made sure that the people who worked for him understood that was the policy. He actually was sued twice by the Justice Department. So he has a long record of engaging in racist behavior.
Yes, now, as far as the lawsuit, yes, when I was very young, I went into my father's company, had a real estate company in Brooklyn and Queens, and we, along with many, many other companies throughout the country, as a federal lawsuit, were sued. We settled the suit with no admission of guilt. It was very easy to do, but they sued many people.
We'll have a brief summary of the news at the end of the program tonight. The rest of the hour will be devoted to an interview with President Clinton that I conducted late this afternoon. I began with questions about a story in the Washington Post and elsewhere this morning about a new investigation by the Whitewater Independent Counsel. It's of allegations the president asked a former aide, Monica Lewinsky, to lie about having an affair with him. The Post said another former White House aide surreptitiously taped conversations with Lewinsky in which she described the alleged affair and attempts to get her to testify falsely. Whitewater counsel Kenneth Starr now has the tapes, the Post said. Starr's office confirmed the probe had been expanded but would not elaborate. I spoke with the president in the Roosevelt Room at the White House. Mr. President, welcome.
Thank you, Jim.
The news of this day is that Kenneth Starr, the independent counsel, is investigating allegations that you suborned perjury by encouraging a 24-year-old woman, former White House intern, to lie under oath in a civil deposition about her having had an affair with you. Mr. President, is that true?
That is not true. That is not true. I did not ask anyone to tell anything other than the truth. There is no improper relationship, and I intend to cooperate with this inquiry. But that is not true.
No improper relationship. Define what you mean by that.
Well, I think you know what it means. It means that that there is not a sexual relationship, an improper sexual relationship, or any other kind of improper relationship.
You had no sexual relationship with this young woman?
There is not a sexual relationship. That is accurate. We are doing our best to cooperate here, but we don't know much yet. That's all I can say now.
Welcome to today's program. Negotiation Ethics for Lawyers, is Paltering ethical? My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. I'd like to welcome you to the latest installment in our popular Negotiation Ethics for Lawyers series. Today's topic is paltering, and before I define what paltering is, I thought I would show you two famous examples of paltering by two famous and also quite infamous politicians, Donald Trump and Bill Clinton. In fact, the last segment in which Bill Clinton palters to avoid a direct question from newsman Jim Lehrer about whether he had had sexual relations with former White House intern Monica Lewinsky is arguably the most famous palter in history, so I thought it was fitting to start our program with these great clips. So, what is paltering? Paltering is defined as the active use of truthful statements to create a false impression. In our Bill Clinton example, Clinton actively makes several truthful statements, such as, "There is not a sexual relationship," which were literally true because by the time of the interview, Ms. Lewinsky was no longer working in the White House, and Clinton was no longer in contact with her, to give the false impression that he never had sexual relations with her at any time in the past. In the Donald Trump clip, Trump evades the question about whether his company discriminated against African American tenants, which was the charge brought by the Department of Housing and Urban Development, by making a series of true statements such as, When I was really young, I went into my father's company, and we, along with many, many, many other companies throughout the country, it was a federal lawsuit, were sued to avoid answering the question. This is paltering, and it is the topic of our presentation here today. Paltering is thus distinguished from two other concepts: lying by commission, where you misstate facts, and lying by omission, where you fail to provide information. While all three tactics involve an underlying motive to deceive the target, paltering is distinct from both lying by omission and lying by commission. Unlike lying by omission, paltering involves the active use of statements, and unlike lying by commission, paltering involves the use of truthful statements. Lying by omission and paltering are similar in that paltering often involves a failure to disclose relevant information, but unlike lying by omission, paltering involves the active disclosure of true but misleading information in an effort to deceive the target. If you're interested in learning more about how paltering has come to be classified by academics as a distinct form of deception, I refer you to a great article entitled "Artful Paltering: The Risks and Rewards of Using Truthful Statements to Mislead Others" that appeared recently in the Journal of Personality and Social Psychology. It was written by professors from Harvard's Kennedy School of Government and from the Harvard and Wharton Business Schools, and the studies they have done in this area are pretty fascinating. One surprising insight that I will talk more about later is that people who palter don't think it is as bad as lying by commission because they told the truth, whereas the targets of paltering think it is just as bad as lying by commission because they were misled just the same. This echoes a broader point I've made in earlier presentations that people come into negotiations with different expectations of what conduct is acceptable and what is out of bounds. Paltering, it seems, fits right in as a negotiation dirty trick that some people find completely acceptable, while others regard it as completely out of bounds. We'll consider these opposing views, as well as what the legal ethics rules have to say about paltering in today's program. So we're going to do three things today. First, we're going to examine the tactic of paltering in some detail, how it works, and why people have such different views on whether it is ethical, and in the process, discuss our hypothetical negotiation between lawyers. Second, I will review the ethics rules that apply to lawyers in negotiations and discuss whether paltering in this context is permitted by the rules. Third, I will teach you some negotiation techniques that you can use when your opponent is paltering to protect yourself and your client from being deceived. Let's start by taking a deeper dive into the tactic of paltering. When academics recently started talking about a new form of deception called paltering, I was fascinated. For years, I've been thinking about deception pretty much exclusively in terms of lying by commission, which is the active use of false statements, such as telling a prospective buyer that the faulty transmission on your car works great, and lying by omission, which is the withholding of relevant information, such as failing to mention anything to the buyer about the faulty transmission, even when the buyer asks you if there are any mechanical problems with the car. Now, there is a third category called paltering, which is the active use of truthful statements in an effort to deceive, such as saying to the buyer in response to a question about whether the car has had any mechanical problems, "Hey, this car drives very smoothly and handles very well. Just last week it started up with no problems in very cold weather." That is what paltering is, and as I have seen, politicians use this tactic all the time, but so do lawyers when they are representing their clients both in and out of negotiations. Before I talk about whether paltering is ethical, let's take a moment to examine why it is so common and why it works so well. Although academics have only recently started thinking about paltering as a distinct form of deception, the tactic of paltering is of course not new and probably has been around as long as there has been language, or at least politicians. It's just how it's being categorized and studied by academics that is new. And of course, lying itself is hardly uncommon in our society. Previous studies have found that on average, people tell 1 or 2 lies a day, often to partners, family members, friends, and work colleagues, many of them little white lies that are considered harmless. The prevalence of lying, or at least of lying by omission or paltering, is also confirmed by the oath that each of us takes when we are sworn in to testify in court. That oath is, "Do you swear to tell the truth, the whole truth, and nothing but the truth?" Why isn't it simply, "Do you swear to tell the truth?" I think it's because we are accustomed to telling partial truths and convincing ourselves that by doing so, we are not lying. If you ask your teenage daughter who arrives at home after midnight where she was, and her answer is that she was at her friend Jane's house, but it turns out that after an hour at Jane's, she spent the rest of the time at a fraternity party, did your daughter lie to you? Perhaps not, as her statement was literally true. She just left out the rest of the story. But if, before you asked her the question, you had made her take an oath to tell the truth, the whole truth, and nothing but the truth, which I know that I'm considering once my daughters become teenagers, I think most people would agree that she would have broken that oath by not revealing that she had left Jane's house to go to the fraternity party. Certainly, your daughter's intent was to deceive you, which is also perhaps why there is an old Yiddish proverb that says that a half-truth is a whole lie. While lying and the telling of half-truths is common, one question you might have is whether anyone, apart from these academics, can identify paltering as a distinct form of deception. So let's give you a little test to see if you can distinguish paltering from lying by commission and lying by omission. This is the same test that researchers used in a recent study to see whether lay people could correctly identify paltering, lying by commission, and lying by omission. Here is the scenario they were asked to imagine. Over the last 10 years, your sales have grown consistently, but next year you expect sales to be flat. If you are asked in an interview, how do you expect sales to be next year, you can respond in one of three ways. The first option is to say, I expect sales to grow next year. The second option is to stay silent even if the interviewer continues by saying, since sales have gone up in the last 10 years, I expect them to go up next year. The third option is to say, well, as you know, over the last 10 years, our sales have grown consistently. Can you spot the palter, the lie by commission, and the lie by omission among these options? The statement, I expect sales to grow next year, is the lie by commission because it is an affirmative false statement. The statement, well, as you know, over the last 10 years, our sales have grown consistently, is the palter because it is the active use of truthful statements in an effort to mislead. And staying silent in the face of the interviewer's statements is the lie by omission because it holds back relevant information in an effort to mislead. The majority of respondents in the study got it right, which means that lay people can distinguish between paltering, lying by commission, and lying by omission. This also suggests that when most people choose to palter, instead of lying by commission or lying by omission, the choice is a conscious one, and in most cases, a choice people make because they think paltering is ethical, or at least less unethical than the other two options. In fact, that is exactly what the researchers found. Most people think that paltering is more ethically acceptable than both lying by commission and lying by omission. I don't agree with that, and we'll shortly see whether the legal ethics rules take that view. But it's interesting that most people think paltering is less unethical than the other two options. How common is paltering in negotiations? Again, I have some insightful results from a recent study of 184 mid to senior level business managers who were enrolled in an executive education course at Harvard Business School. All of the managers negotiate as part of their business activities, and collectively, they represented a variety of industries, so it wasn't just shifty Wall Street bankers or dodgy entertainment types or slick product marketers who took part in the study. 52% of the managers reported that they had paltered in some or most of their negotiations, whereas a smaller number, 21%, confessed to having lied by commission. I think that data squares with what most experienced negotiators believe, namely that in the majority of negotiations, someone has engaged in paltering, and in perhaps one negotiation in 5, someone has lied by commission. In the entertainment industry, those numbers may well be a lot higher, but I digress. The point is that paltering likely happens in the majority of negotiations, and many people who palter do it because they think it is ethical, or at least less unethical, than lying by commission. I don't agree with that view, and I think that paltering is as unethical as lying by commission, particularly when you palter in response to being asked a direct question, as opposed to merely paltering unprompted. As we will see, the legal ethics rules provide some support for the notion that paltering is not as unethical as lying by commission, but as I've noted in prior presentations, I don't think a lawyer acts ethically, or even in his client's best interests, when he or she deceives another in a negotiation, even if his or her conduct isn't clearly prescribed by the legal ethics rules. Apart from the ethics rules, I think the main reason some people think that paltering is ethical is that because they are telling the literal truth, they aren't lying and they aren't doing anything wrong. Interestingly, many of these same folks will place the blame on the target who was misled by believing it was his fault because he wasn't paying closer attention to what was being said. Blaming the victim is a clever twist and one that is only really possible with paltering because the statements are literally true. It's hard to blame the victim who believes your lies by commission, although of course the law of fraud, which requires reliance on a false statement to be reasonable in order to be actionable, will let liars off the hook if their lies are believed by someone who should have known better. Of course, the law of fraud is not the same as the rules of legal ethics, and as we will revisit shortly, a lawyer who lies by commission about a material fact with knowledge of its falsity commits an ethical violation, whether or not the victim believed his lie. If paltering is unethical, as I've argued it is, why do people who engage in paltering in negotiations do it? According to the Harvard Business School study, 88% of the managers in the study said they paltered in negotiations in an attempt to get a better deal. And that's because paltering, like the many other forms of deception and negotiation I've discussed in these programs, can be hard to detect. And if it goes undetected, the palterer often can walk away from the table having obtained a better deal than he otherwise would have absent the deception. So the bottom line is that paltering is common in negotiations. Many people palter consciously because they think it is ethical, or at least less unethical than lying by commission or lying by omission. And they do it because they think it will help them get a better deal. It's time now to take a look at the legal ethics rules that apply to lawyers in negotiations to see whether paltering is permitted under those rules. We'll use a hypothetical negotiation between lawyers to help us illustrate how the legal ethics rules apply in negotiations and determine whether paltering falls on the right or wrong side of those rules. The hypothetical I've chosen today involves the acquisition of a small family-owned winery, Peter Sellers, by a large alcoholic beverage and tobacco conglomerate, Worldwide Holdings Alcohol and Tobacco, or WHAT for short. Peter Sellers is represented in the negotiation by Michael Cusack, the youngest member of the family and a newly minted lawyer who just passed the California bar in July. Cusack is really smart and also really handsome, but he doesn't have much experience either as a lawyer or a negotiator. On the other side of the table is Douglas Brackman, a senior partner with Mackenzie Brackman, a prominent Los Angeles law firm. Brackman has been practicing law for 3 decades and specializes in mergers and acquisitions. Over the years, he has represented WHAT in dozens of acquisitions, ranging from small deals like the one for Peter Sellers to transactions valued at more than $1 billion. Brackman is a skilled and sneaky negotiator, always looking to take a sharp edge if he thinks by doing so he can get a little extra for his client. To borrow a phrase from Wall Street, Brackman is the sort of fellow who would sell his own mother for $1 and send her COD. It should be clear from our hypothetical, but let's make it explicit. Cusack and Brackman do not know each other and are highly unlikely to do business with each other again. The acquisition of Peter Sellers is almost certain to be a one-and-done negotiation between these two players, which sets up well for these lawyers to engage in sharp practice because they don't expect to be dealing with each other in a future deal. I typically add this fact to our hypotheticals to make the point about the opposite case, where the lawyers do deal regularly with one another and others in the same industry. In those cases, your reputation becomes very important because you will negotiate with the same people over and over again. If you lie or use other negotiation dirty tricks, you will get a reputation for sharp practice that in most cases will make it more difficult for you to close deals in the future. Aside from the legal and ethical restrictions, reputation is another good reason to avoid sharp practice. Let's take a look at the first scene in our hypothetical negotiation.
With respect to the sale price, I heard your client has paid a lot more than $5 million when it bought the Cifuentes family winery just last year. Is $5 million the most your client has paid for a winery with an output of 30,000 cases a year?
I'm glad you brought up the Cifuentes family deal because I handled that one too. Although Victor Cifuentes is a gifted winemaker, he's a lousy businessman and he was running that place into the ground. The profits had dried up and he was lucky my client was there to bail him out before that balloon payment came due on his mortgage. Besides, by the time WHAT bought them, they were shipping a lot less than 30,000 cases a year.
The ethical issue here is that WHAT paid $7 million for the Cifuentes family winery, which at the time was producing 30,000 cases a year, but shipping only 20,000. not because sales were slow, but because the winery decided to hold some of its best wines for its 10th anniversary library release in a few years' time. In addition, while it is true that Cifuentes' family had not generated any profit in the last year, it was because they had reinvested those profits to build a brand new tasting room that they expected to triple the number of visitors to the winery. So what is Brackman doing here? This is classic paltering, the active use of truthful statements to create a false impression. Brackman is also using paltering to avoid answering Cusack's direct question, which was, is $5 million the most your client has paid for a winery with an output of 30,000 cases a year? Instead of answering that question, he makes a series of truthful statements, such as their profits had dried up and they were shipping a lot less than 30,000 cases a year, in an effort to give Cusack the misleading impression that the Cifuentes family winery wasn't as valuable as he had heard. Brackman also is careful to make a statement about how many cases Cifuentes family shipped, 20,000, as opposed to how many they produced, 30,000, so he can mislead Cusack into thinking that their output had dropped below what Peter Sellers is currently producing for the purpose of valuing the two wineries. Big picture, Brackman is using paltering to dodge the $5 million question. Is $5 million the most Watt has paid for a winery like Peter Sellers? Just like President Clinton dodged the question about whether he had had sexual relations with that woman, Miss Lewinsky. Is Brackman's paltering ethical? If you've seen prior programs in this series, you'll know that I never jump right into the legal ethics rules without first pausing to discuss whether sharp practice is moral and whether you want to be the type of lawyer and person who engages in it. We've made the argument consistently that it's never a good idea to negotiate like Brackman does here because it isn't moral to deceive the other side, even if you are negotiating on behalf of a client and not yourself, even if the other side isn't listening carefully enough to the words you've chosen, or even if you can get away with it. The duty of zealous advocacy doesn't require lawyers to extract every penny off the table in a negotiation, and developing a reputation for sharp practice can make it harder for you to negotiate future deals in a community and industry filled with repeat players who regularly deal with one another. So if you don't like the moral argument, how would I explain my decision to deceive the other side to a mentor or a member of my family whose opinion I value? You should consider the practical downsides of developing a reputation for deception. We should try to remember that as lawyers, we should behave like the professionals we are and not perpetrate the stereotype that all lawyers are not only trained to lie, but are generally very good at it. Climbing down from my soapbox now, let's examine how the legal ethics rules treat Brackman's paltering. Specifically, can the active use of truthful statements intended to deceive the other side in a negotiation violate the rules of ethics? Since Brackman is a California lawyer, the place to start is California Business and Professions Code 6068, which states that it is the duty of an attorney, quote, to employ, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth, and never to seek to mislead the judge or any judicial officer by any artifice or false statement of fact or law, end quote. This general pronouncement is helpful, but only as far as it goes, and with regard to paltering in particular, I think it's ambiguous whether Section 6068 proscribes paltering. First of all, Section 6068 instructs lawyers to employ, quote, only those means as are consistent with truth, and you can argue that paltering, the active use of truthful statements to deceive another, is not a means consistent with truth, both because the speaker had the intent to deceive the target and because the target, in fact, was deceived. Since Section 6068 is binding on all lawyers in California, Brackman could be in trouble, as the state bar certainly could conclude that his paltering was not a means that is consistent with truth. On the other hand, Section 6068 goes on to state expressly that a lawyer may not, quote, mislead a judge or judicial officer by an artifice or false statement of law or fact, end quote. While this clause does not modify the first one, which prescribes any means that are not consistent with truth, it does narrow the types of conduct that a lawyer may not use to mislead a judge or judicial officer to, quote, an artifice or false statement of law or fact, end quote. Does this suggest that Section 6068 is really only prohibiting lawyers from making false statements of law or fact when it states that lawyers shall employ only those means as are consistent with truth? It's certainly possible to make that argument, but as noted, that's not how the provision is constructed, and based on the plain language, The requirement that a lawyer employ only those means as are consistent with truth is not limited to avoiding making false statements of material fact or law. In the same way, I think you'd be wrong to read Section 6068 to allow you to make false statements of material fact or law to third parties as long as you are not making those statements to a judge or judicial officer. As a result, I think the better reading is that Brackman's paltering likely does violate Section 6068's prohibition on using means that are inconsistent with truth, even if he never makes a false statement of material fact or law. But it's not entirely clear, and a clever lawyer like Brackman might be able to get away with it, given this ambiguity in the rule. How would Brackman's conduct be analyzed in states that follow the ABA model rules of professional conduct? I think we come to more or less the same ambiguous result under the model rules. The place to start is Model Rule 8.4, which states that, quote, "It is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation," end quote. Fraud, deceit, and misrepresentation have very clear and specific definitions, and none of those is going to be triggered by Brackman's conduct here, which consists exclusively of true statements. I think the only potential hook you would have under Model Rule 8.4 is, quote, "conduct involving dishonesty," end quote, because Brackman clearly is not being honest with Cusack in response to his direct question whether $5 million is the most Watt has paid for a winery like Peter Sellers, and because Brackman clearly intends to deceive Cusack. I think you might have enough here to find a violation of Model Rule 8.4, that paltering in response to a direct question constitutes conduct involving dishonesty, but it's not a slam dunk. You also might have more trouble finding a violation if someone palters sua sponte, instead of paltering in response to a direct question, as Brackman does here. Our tradition in negotiation is that the parties are only entitled to what they can negotiate, and if a party doesn't ask the right questions, he or she might not find out the information he or she needs to negotiate a better deal. On the other hand, if you're prepared and skilled enough to ask a direct question, and instead of answering that direct question, the other side palters, I think you can make a better case that the other side is engaging in conduct involving dishonesty by dodging your direct question. But at the end of the day, I don't know that a palter, even in response to a direct question, constitutes a violation of Model Rule 8.4, similar to the conclusion I reached in California under Section 6068. Let's take a look at another model rule to see if it sheds any more light on how Brackman's conduct would be viewed in a model rule state. Model Rule 4.1 is entitled Truthfulness in Statements to Others, and it provides that, quote, "In the course of representing a client, a lawyer shall not knowingly, A, make a false statement of material fact or law to a third person, or B, fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6, end quote. Once again, the first part of the rule doesn't apply because Brackman didn't make any false statements. I should point out that apart from his truthful statements, the other statements Brackman made, such as Cifuentes is a lousy businessman who was running that place into the ground, are statements of opinion and not fact, so they wouldn't qualify even if they were in some sense false. That's another thing sneaky negotiators do a lot. They make statements that sound factual when they are really just opinions, which generally aren't actionable under either the ethics rules or the law of fraud. What about the second part of the rule? Doesn't Brackman violate it by failing to disclose a material fact when disclosure is necessary to avoid assisting a fraudulent act by a client? Isn't Watt trying to defraud Peter Sellers by paying less for the winery than its fair value? Unfortunately, I don't think what Brackman is attempting to do here is fraud, at least in terms of what I've seen so far, because he hasn't made any material false statements of fact on which Cusack can claim to have relied to his detriment, all of which is required to state a claim for fraud. The type of conduct that this part of Model Rule 4.1 typically reaches is a case where a client makes a false statement of material fact. Let's say in this case that Watt's CEO told Cusack that Watt paid only $5 million for the Cifuentes family winery, when in fact it had paid $7 million, which then creates a duty on the part of Watt's lawyer to correct that false statement, unless the disclosure would be prohibited by the rule against disclosing client confidences. But those aren't the facts we have here. No one told Cusack that Watt only paid $5 million for the Cifuentes family winery, or made any other false statement of material fact or law, so there was no obligation on Brackman to correct anything. Model Rule 4.1 definitely does not require a lawyer to disclose facts in a negotiation that are harmful to his client's interests, such as how much what paid for the Cifuentes family winery. Otherwise, a negotiation would not be a negotiation as much as it would be an impartial inquiry into the true value of the subject of the negotiation, where both sides would have a duty to disclose all information relevant to the question of value, whether it is helpful or harmful to their interests. That is definitely not the law, at least in the United States, where there is no general duty to negotiate in good faith, absent a contractual obligation to negotiate, which would imply such a duty in the performance of that contractual obligation. Indeed, the comment to Model Rule 4.1 makes this point exactly, stating that, quote, "A lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party of relevant facts," end quote. So, the duty specified by the second part of Model Rule 4.1 is and must be limited to disclosing facts when necessary to prevent a client from committing fraud. Here, there is no fraud, at least not yet, and thus no duty to disclose anything under Model Rule 4.1. Let's see what happens next in the negotiation.
I'm not sure how to value the 10,000 shares of What stock that you're offering us as part of the sale price, given that What is not a public company. One thing that is important for me to know is whether Arnie Becker, What's founder and CEO, is planning to retire next year, as some in the press have been reporting. Is Becker under an employment contract with What, and if so, what is the end date of his contract?
Obviously, I can't buy any What stock myself because I represent them. But if I were you, I'd jump at the chance to acquire some of their shares as part of this deal. I can't comment on any of the press reports about Arnie's retirement plans. I can tell you that he is less than halfway through his current 5-year employment contract with What, so I wouldn't worry about Arnie's retirement anytime soon.
The ethical issue here is that while it is true that Arnie Becker is less than halfway through his current 5-year employment contract with What, Brackman knows that Becker's contract gives him an out if he decides to retire at any time during the contract term without penalty. The contract would only limit Becker's ability to take another full-time job during the 5-year term. Is what Brackman doing here paltering, or is he using a different dirty trick to deceive Cusack? Brackman is paltering again, but he takes it a step further this time by making an affirmative statement that is really only partially true and is very misleading about Becker's employment contract, which is a little bit different from the paltering we saw in the first hypothetical, where everything Brackman said was literally true and only misleading because he paltered instead of answering Cusack's direct question about the purchase price for the Cifuentes family winery. In this hypothetical, Brackman's paltering starts with his statement, "Obviously, I can't buy any What stock myself because I represent them, but if I were you, I'd jump at the chance to acquire some of their shares as part of this deal." The first part of this statement is a palter. It's a true statement that Brackman can't buy What stock legally because he has inside information about the company through his representation of them. And the second part is Brackman's opinion, not a statement of fact. His next statement, "I can't comment on any of the press reports about Arnie's retirement plans," isn't a statement of fact as much as a statement of his present intention, which isn't really a palter, and statements about one's present intentions also aren't going to be actionable under the ethics rules because they aren't considered false statements of material fact. Brackman's final statement is the one I want to focus on here, where he says, "I can tell you that he is less than halfway through his current 5-year employment contract with What, so I wouldn't worry about Arnie retiring anytime soon." What should we make of this one? I think Brackman crosses the line from paltering, which is the active use of true statements to create a misleading impression, to making a statement that is only partially true and is very misleading with respect to the subject of the statement, namely Becker's current employment contract. By saying that Becker is in the middle of his employment contract and that Cusack shouldn't worry about Arnie retiring anytime soon, Brackman misleadingly suggests that Becker is obligated to continue working for What for at least 2.5 more years, when in fact, he can retire at any time without penalty. Happily, the legal ethics rules contemplate just such a scenario, and in this case, Brackman's partially true but misleading statement pushes him over the edge into an ethical violation. As we saw, Model Rule 4.1 expressly prohibits lawyers from making false statements of material fact or law to a third person. The comment to Model Rule 4.1 states that, quote, "A misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. Misrepresentations can also occur by partially true but misleading statements or omissions that are the equivalent of affirmative false statements." End quote. Here, Brackman's partially true but misleading statement about Becker's employment contract is the equivalent of an affirmative false statement and is thus a clear violation of Model Rule 4.1 that could subject him to discipline. Unlike his pure paltering in the first hypothetical, where he made a series of true statements in order to avoid answering Cusack's direct question, Brackman's partially true but misleading statement about Becker's employment contract crosses the line from paltering into lying by commission, where a partially true statement is so misleading that it is deemed to be the equivalent of an affirmative false statement under Model Rule 4.1. I think that is the right result, and that this hypothetical does a good job of illustrating the line between paltering and lying by commission. I think this is the right way to analyze what we've seen so far, but let's play with the hypothetical a bit to see if we can make the line between paltering and lying by commission any brighter when we talk about partially true but misleading statements being deemed the equivalent of affirmative false statements. What if Brackman instead had said, "I can tell you that he is less than halfway through his current 5-year employment contract with what, but of course, nothing in life is guaranteed." Would that be enough to save Brackman's statement here? I actually think that it would be enough, because with partially true but misleading statements, you need to examine carefully the impact the statement is likely to have on the target when considered in its entirety. In the original case, Brackman closes by reassuring Cusack that "I wouldn't worry about Arnie retiring anytime soon," which would leave a reasonable person with the impression that Becker is under a firm commitment for the 5-year term of his contract, which is misleading because Becker can retire at any time without violating his contract. In the second case, Brackman closes by cautioning Cusack that, of course, nothing in life is guaranteed, which, although somewhat general, changes the statement just enough to make it partially true and still misleading, but not something that rises to the level of an affirmative false statement under Model Rule 4.1. Clear as mud? Yes, I think this example shows that it's not possible to draw a bright line between mere paltering on the one hand, partially true but misleading statements that are the equivalent of affirmative false statements under Model Rule 4.1 on the other hand, and partially true but misleading statements that are not the equivalent of affirmative false statements on the third hand, and that so much of the analysis is driven by context and is in the eye of the beholder. What I would say is that the lack of a clear dividing line between paltering, which may or may not be okay under the ethics rules, and partially true but misleading statements, which may or may not be deemed the equivalent of affirmative false statements, makes it even more important for lawyers to stay far away from that line in the course of representing your clients in general and in negotiations in particular. You'd hate to think that you are safely on one side of the line and later have the state bar or a court conclude that you are in fact on the other side. I think this is a good point to talk about some of the risks of paltering in negotiations, apart from the risk of being found to have violated the legal ethics rules, which of course can have serious consequences, including potentially suspension or disbarment. Like many of the other dirty tricks in negotiation that I've discussed in these programs, paltering creates a couple of risks for anyone who might be thinking about using this tactic. The first risk is that your paltering could stop the negotiation in its tracks if the other side feels misled. As we learned earlier from the Harvard Business School study, targets of paltering feel just as misled and consider the practice just as unethical as lying by commission. If someone tells bald-faced lies to you in a negotiation, do you have any interest in continuing to negotiate with that person, or are you more likely to put a stop to the dialogue? Unless parties are under a court-ordered or contractual duty to negotiate, such as a court-ordered settlement conference or a contractual right of first negotiation, they are free to walk away from the table at any time, and having the other side lie to you is frequently considered a pretty good reason to break things off. Assuming your goal in participating in the negotiation is to see if an acceptable deal can be reached, engaging in paltering that causes the other side to withdraw from the negotiation does not serve your or your client's interests. The other major risk of paltering is that it can damage your reputation for truthfulness, which, in turn, can make it harder for you to negotiate against that same party in future deals or against other parties who might learn of your reputation for dishonesty. Once again, the Harvard Business School study produced some powerful anecdotal evidence of the negative effect that paltering can have on its victims. Here's how one professor summed up those findings. Quote, "In class, I have some fascinating discussions. People say to the person they deceive, "No, I didn't lie." Truthfully, they didn't lie, but they also gave the wrong impression, she says. And the people who are deceived have a strong reaction. They code the people as liars and actually keep their anger with them for the entire semester. Being lied to produces very strong feelings that affects the way people interact with each other in the future." End quote. I think this is a very important point and one that distinguishes paltering from some of the other dirty tricks I've examined in these programs, such as good cop, bad cop, take it or leave it, or misrepresenting one's true goals or objectives. While people's opinions of the severity of using a dirty trick like good cop, bad cop in a negotiation can vary widely, in general, most people are willing to accept some gamesmanship as part of the negotiation process, and many of those same people feel free to engage in it themselves for the same reason. But the vast majority of people, and the legal ethics rules, put lying in a whole different category of conduct that is not expected or allowed. Given that many people who are victims of paltering think it is the same as lying by commission, this should give you pause before you use paltering as a tactic in your next negotiation because of the risks I've been discussing. While you certainly can try to explain away what you did, "I didn't lie, I was telling the truth," or blame the victim for having been deceived, obviously you weren't listening carefully enough to what I actually said, neither of those arguments is likely to change the mind of someone you've deceived to his detriment in a negotiation through your artful paltering. And given the studies that have been done to substantiate this reaction on the part of victims of paltering, it's not the case that a counterparty who feels this was overly sensitive or inexperienced in negotiations. At the end of the day, paltering creates real risks of stopping a negotiation that could lead to a deal that benefits your client more than not having a deal in its tracks and harming your reputation as a negotiator that you should consider before engaging in this type of behavior. Shifting gears a bit, are there things Cusack could do here in response to Brackman's paltering and partially true but misleading statements to avoid being deceived? One benefit of most negotiations, unlike oral arguments in court or interviews with presidential candidates, is that there is no time limit on them, which makes it difficult for a palterer to simply run out the clock on you with more paltering. If you've read Getting to Yes by Roger Fisher and Bill Urey, or seen one of our prior programs in this series, you'll likely recognize that asking questions is a great way to avoid being deceived in a negotiation in general and in response to a palterer in particular. Let's take a look at some questions Cusack could ask here in response to Brackman's statements about Becker's employment contract.
That's helpful. So Mr. Becker can't retire for at least 5 years without breaching his employment contract with what? Thank you for providing some context for the deal. How much exactly did what pay to acquire the Cifuentes family winery?
The first example is a great question, and it forces Brackman into choosing between just a couple of options for his response, none of which is great for him. The first option is to keep paltering and avoid answering Cusack's direct question about the terms of Becker's employment contract. Even for an inexperienced lawyer and negotiator like Cusack, someone who continues to avoid answering your direct questions is obviously not being straight with you, presumably because the truthful answers to your questions are not the ones he wants to give. Brackman's second option is to remain silent and lie by omission, which in this context should make it pretty obvious to Cusack that the answer to his question is no. A third choice would be to lie by commission by simply answering yes, which would be both an ethical violation under Section 6068 in California and both Model Rules 8.4 and 4.1, as well as a predicate for a potential fraud claim if the lie was about a material fact on which Cusack's client relied to its detriment and was damaged as a result. A fourth choice would be to respond that the terms of Becker's contract are confidential and that Brackman is not able to discuss them with Cusack. Whether this is true or not, and Cusack could point out that Brackman already breached that confidentiality by telling him it was a 5-year term and that Becker is halfway through that term now, this is a response that one certainly could expect from Brackman once Cusack starts to drill down on the specifics of Becker's employment agreement. This is likely also how Brackman would respond to Cusack's direct question: how much exactly did Watt pay to acquire the Cifuentes family winery? So let's discuss this possible response in some detail. What should Cusack do if Brackman raises confidentiality as a way to deflect Cusack's question about Becker's contract or the true purchase price for the Cifuentes family winery? Experienced negotiators know that this comes up a lot in negotiations. The other side references another deal that somehow supports the position they are taking here, but when asked about it in more detail or to provide a copy of it, they quickly retreat behind a confidentiality provision that, unfortunately, prohibits any such disclosure. The only good response to this is for Cusack to say that he can't rely on anything that can't be established by providing a copy of that agreement. It's not that I don't trust you, Douglas, but it's my client. I have to duty to my client to trust but verify everything on which I might rely in agreeing to this important deal, and I'm sure you can understand that, and to put it back on Brackman to provide it. If Cusack is firm enough, and if it truly matters enough to both parties in the negotiation to be able to refer to the terms of the agreement at issue, the parties will find a way to get that proof into the negotiation, such as by obtaining a waiver of the confidentiality provision from Becker and/or the Cifuentes family winery, providing a redacted copy of the contract that omits the most sensitive information, such as Becker's compensation or the mechanism by which the sale price was determined in the winery deal, etc. The bottom line is that you can't allow the other side to deceive or mislead you by referring to another deal or agreement and then hide behind a confidentiality provision to deny you the proof of those assertions. That's a fundamental lesson for all negotiators, in particular, and for inexperienced ones like young Cusack here. Another benefit of asking questions when you think you are being deceived in a negotiation is that you often force the other side into making an affirmative false statement that potentially sets them up for a fraud claim, or alternatively, continuing to avoid answering your questions, particularly in our example by further paltering. As we learned from the Harvard Business School study, and I agree, paltering in response to a direct question is generally considered to be more unethical than unprompted paltering. That is because if you are prepared and skilled enough to ask the right question in a negotiation, you're entitled to receive a straight answer to your question, or at least no response if the other side refuses to answer the question, which of course can lead you to draw valuable inferences from their direct refusal to answer, just like a defendant who pleads the fifth in a criminal case. The point is that unprompted paltering is accepted and frankly expected by lawyers engaged in advocacy on behalf of clients, whether that advocacy occurs in oral arguments in court or in negotiations, and most people don't find much, if anything, wrong with it. But when you palter in response to a direct question with the intent to mislead the questioner, that's where most people and most negotiators begin to take issue with your conduct. As we've seen, it's also where the legal ethics rules can rise up and bite you, deeming your paltering in response to a direct question conduct involving dishonesty under Model Rule 8.4, or alternatively, a partially true but misleading statement that is the equivalent of an affirmative false statement under Model Rule 4.1. Those are the types of results that you as a lawyer negotiator want to avoid if you value your reputation and your law license. Let's take a look at our next hypothetical.
If I'm being honest with you, my family really isn't interested in selling our winery. As you know, it was not listed for sale, and your client approached us with an unsolicited offer. I agreed to meet with you at your request to discuss the possibility of selling, but my family isn't prepared to sell unless we are talking about a purchase price in the low 8 figures.
The ethical issue here is that Cusack's family is desperate to sell the winery because his parents are eager to retire now that their children are out of school, and it's clear that none of them has an interest in taking up the family business. In fact, before sending Cusack to negotiate with Brackman, the family met and unanimously agreed that Cusack was authorized to sell the winery if he could get at least $2 million for it, much less than the $10 million Cusack told Brackman is the family's reserve price. What is Cusack doing here, and is his conduct ethical? As young a lawyer as Cusack is, he certainly is a quick study in that he's already using some dirty tricks of his own in his first big negotiation with Brackman. That said, he has a lot to learn in terms of his presentation style. For one thing, it's generally a bad idea in a negotiation to preface a comment with, "If I'm being honest with you," since that suggests both that you haven't been honest up to this point and that whatever you're about to say next is almost certainly not the truth. Setting aside his clumsy style, Cusack is clearly misrepresenting his client's goals and objectives by suggesting that his family isn't interested in selling our winery when in fact they are desperate to do so, and offering a grossly inflated estimate of the value of the winery of $10 million by stating that his family would not sell for less than that amount, when they already had agreed to sell for as little as $2 million. He throws in a little paltering of his own for good measure when he offers, "As you know, it was not listed for sale and your client approached us with an unsolicited offer," which is a true statement that Cusack mentions in an effort to deceive Brackman about his client's level of interest in making a deal. Cusack's affirmative misrepresentations and clear attempts to deceive Brackman must be unethical, right? Actually, with this hypothetical, we're playing a bit of a dirty trick on you, because most authorities hold that the sort of misrepresentations Cusack engages in here don't violate the legal ethics rules if they are made in the context of a negotiation. To understand why, we need to go back to the commentary to Model Rule 4.1. which states that, quote, "This rule refers to statements of fact. Whether a particular statement should be regarded as one of fact can depend on the circumstances. Under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category, and so is the existence of an undisclosed principal, except where non-disclosure of the principal would constitute fraud," end quote. Put another way, when lawyers are negotiating, they are allowed to misrepresent their client's estimates of price or value and its intentions as to what would be an acceptable deal, which is exactly what Cusack is doing here. As for Cusack's unprompted palter about the winery not having been for sale, that's not going to be held to violate the legal ethics rules either, for the reasons I discussed before when I analyzed some of Brackman's paltering. The ABA provides further support for this conclusion in its formal ethics opinion 06439, entitled A Lawyer's Obligations of Truthfulness When Representing a Client in Negotiation, issued in 2006. In my favorite passage, the ABA committee starts by observing in classical lawyer fashion that, quote, "It is not unusual in a negotiation for a party, directly or through counsel, to make a statement in the course of communicating its position that is less than entirely forthcoming," end quote. Put another way, lawyers and their clients are expected to lie about some things in negotiations in order to get a better deal. And as we've seen from the research, lying certainly is common in negotiations. The ABA committee then goes on to try to distinguish between the lies a lawyer representing a client is allowed to tell in a negotiation and those he or she is not allowed to tell, consistent with his or her obligations under the legal ethics rules. As you can imagine, this is not an easy task, and at the risk of being too critical, I think the ABA mostly got it wrong in terms of what it professed in Ethics Opinion 06439. That said, courts and state bars routinely look to the ABA model rules and the formal ethics opinions interpreting those rules in determining whether a lawyer has violated the rules of ethics. So whether or not I agree with the ABA committee, it's important to know that what Ethics Opinion 06439 provides, as it will be persuasive, although not binding precedent in many cases. So we need to go through it in some depth. Starting with Model Rule 4.1's prohibition on making a false statement of material fact to third persons, the ABA committee found that even in the negotiation context, where lawyers and clients are expected to lie, a party's actual bottom line or the settlement authority given to a lawyer is a material fact that the lawyer may not misrepresent to the other side in a negotiation. However, the ABA also found that a lawyer may downplay a client's willingness to compromise or present a client's bargaining position without disclosing the client's bottom line position in an effort to reach a more favorable resolution. Formal Ethics Opinion 06439 goes on to suggest that a lawyer also may engage in the following conduct without violating Model Rule 4.1, misrepresenting your current position and understating your willingness to make concessions or compromise, deceiving as to the ultimate goals and objectives, exaggerating the strengths and minimizing the weaknesses of your factual or legal position or the value of the subject matter, and overstate your confidence in the availability of alternatives to reaching a deal. Why does the ABA committee believe that statements along these lines in a negotiation are not false statements of material fact? According to Formal Ethics Opinion 06439, quote, "Such remarks are often characterized as posturing or puffing and are statements upon which parties to a negotiation ordinarily would not be expected justifiably to rely and must be distinguished from false statements of material fact," end quote. I've been critical of drawing a line here because in terms of what statements the other side in a negotiation is likely to believe, a statement about a party's actual bottom line or the settlement authority given to a lawyer are not, in my view, likely to be believed or statements upon which a party should be expected to rely. On the flip side, if you think about a negotiation as an opportunity for the parties to discuss their goals and objectives in an open and honest way to see if there are opportunities for mutual gain, i.e. to give one party something that it values a lot at a low cost to the other party and vice versa, allowing parties to misrepresent their goals and objectives makes that ideal of an interest-based negotiation much harder to achieve. With all of that said, this is where the ABA committee in Formal Ethics Opinion 06439 decided to draw the line. Lying about your bottom line or settlement authority is forbidden, while lying about your goals and objectives is not. And so that's how Rule 4.1 is to be interpreted in the context of negotiations. Using that as the test, Cusack's misrepresentations here don't violate the legal ethics rules. One important caveat to this conclusion that I alluded to before: Because Cusack is a California lawyer, his conduct is governed not only by the ABA model rules, which California has adopted, but also by California Business and Professions Code Section 6068, which states that it is the duty of an attorney, quote, to employ, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth, and never to seek to mislead the judge or any judicial officer by an artifice or false statement of fact or law, end quote. It is an open question whether Section 6068's prohibition on employing means that are inconsistent with truth would allow a lawyer in the context of a negotiation to lie about his client's goals and objectives, as ABA Model Rule 4.1 and Formal Ethics Opinion 06439 suggest. I think you are taking some risk as a California lawyer relying on these persuasive and not binding authorities as support for engaging in this conduct in the face of Section 6068's very broad, albeit very general, prohibition against engaging in means that are inconsistent with truth. One other question worth asking before we move on: in deciding whether Cusack has violated the legal ethics rules, does it matter how long he's been a lawyer or how much experience he has had in representing clients in these types of negotiations? The answer is that it might make a difference, not so much in determining whether Cusack's client violated the ethics rules, but more in terms of deciding, if it did, what punishment to impose. I've read a lot of opinions in attorney disciplinary proceedings, don't ask me why, and most state bars will take into account a lawyer's experience as a lawyer and experience handling the type of matter that is at issue in deciding what punishment, for example, whether to censure, suspend, or disbar a lawyer, is warranted in the circumstances. Generally, lawyers who are more experienced are more likely to get steeper sanctions when they are found to have violated the rules than lawyers who are less experienced, on the theory that the former should know better. Interestingly, lawyers who are famous, think F. Lee Bailey, are even more likely to be disbarred for their misconduct than lawyers who are not famous. In F. Lee Bailey's case, who was disbarred by the Florida Supreme Court and reciprocally disbarred by other states, including Massachusetts, the Supreme Judicial Court of Massachusetts in that case expressed this sentiment this way, quote, "We see nothing in mitigation, that Bailey has had a long and highly successful career, as attested by those who submitted letters to the Board of Bar Overseers urging it not to seek Bailey's disbarment, does not mitigate these multiple violations. Our standards of ethical practice apply to all attorneys, whether they are well known for their victories in high-profile cases or whether they practice law in quiet obscurity. If anything, the fact that Bailey committed such grave misconduct despite his vast experience as a seasoned litigator only serves to heighten the seriousness of his offenses," end quote. Apart from the point about should have known better, you can imagine courts choose to disbar famous lawyers when they are found to have violated the ethics rules, in part to deter others. So even if Cusack were found to have violated the legal ethics rules here as a result of his misrepresentation under Section 6068, and contrary to what Rule 4.1 and Formal Ethics Opinion 06439 suggest, he likely would receive some leniency in the penalty phase in consideration of inexperience and the fact that, as the Massachusetts court put it, he practices law in quiet obscurity. If lawyers are allowed to misrepresent their goals and objectives, as Cusack does here, what can a lawyer on the other side do to avoid being deceived? I think there are several things a lawyer can do to counter this tactic in a negotiation. Let's take a look at one of them.
Thanks for being straight with me. I'm glad your family isn't that interested in selling, because Watt is currently in talks to acquire another winery that's very similar to Peter Sellers. Watt only wants to buy one winery at this time, so we'll focus our efforts on those other discussions, especially given how differently we value your winery.
So what Brackman is doing here is fighting fire with fire, misrepresenting his client's goals and objectives in response to Cusack doing the same. Just like it wasn't unethical for Cusack to do it, Brackman isn't going to be held to have violated the ethics rules by engaging in the same conduct with the same caveat about Section 6068 that I mentioned before. Whether this response is an effective one depends on what type of a negotiation you have. If you're engaged in an old-school distributed bargaining situation where there are 10 issues on the table and you win the negotiation if you can get 6 or more of the 10, leaving the other side with 4 or less, then responding in kind might be a good idea. If, on the other hand, you're engaged in an interest-based negotiation where the parties are looking to expand the pie beyond the 12 issues and to find opportunities for mutual gain, misrepresenting your goals and objectives is going to make it hard for the other side to help identify those opportunities. That's why I don't recommend fighting fire with fire or misrepresenting your goals and objectives in a negotiation, because it can foreclose what otherwise would be an opportunity to find things to trade that are win-win for the parties. Let's take a look at another possible response by Brackman.
That's interesting. What if we offered your family $3 million to buy the winery, but gave them the opportunity to continue to run it working as what employees?
I like this response better because when Brackman suspects Cusack is trying to deceive him about his client's goals and objectives, Brackman comes up with a clever response that will allow him to test for deception. If Cusack's family doesn't want to sell, presumably it's because they want to continue making wine at Peter Sellers, and Brackman's offer gives them the opportunity to keep doing that, in addition to receiving $3 million for the winery. Because Cusack's family has no interest in continuing to work at the winery, recall that his parents want to retire and their children don't want to work in the family business, it will become clear pretty quickly that Brackman's proposal isn't something Cusack's client will consider, which, in turn, gives Brackman valuable information that should expose Cusack's attempt at deception. Creating hybrid proposals like the one Brackman floats here is often a very good way to test the other side's stated goals in a negotiation, and I highly recommend that sort of response. What else might Brackman say in response?
That's too bad, because my client's bottom line is $3 million. What won't agree to pay a penny more than that to buy Peter Sellers, so it looks like there's no way for us to make a deal here.
Of course, the ethical issue and ethical violation here is that what has empowered Brackman to pay up to $7 million to acquire Peter Sellers. By misrepresenting what's bottom line, Brackman is making a false statement of fact to Cusack in violation of Model Rule 4.1 and ABA Formal Ethics Opinion 06439. This almost certainly also would be held to violate Section 6068, given its requirement that lawyers employ means only as are consistent with truth. So again, whether you agree or disagree with the ABA Committee in Formal Ethics Opinion 06439, lawyers run a substantial risk of violating the ethics rules when they misrepresent their client's bottom line in a negotiation, so that it is definitely not a response Brackman should make here. That brings us very close to the end of today's presentation on paltering. Before I close, let's spend a few minutes summarizing what we learned about the ethics rules that apply to lawyers in negotiations. We've seen the general rules that require lawyers to be candid in their dealings with others, including Business and Professions Code 6068 in California, and Model Rules 4.1 and 8.4 that apply to lawyers in states that follow the model rules. But we also learned that apart from your bottom line or settlement authority and other material statements of fact or law, which you cannot misrepresent, you may be able to misrepresent certain things in a negotiation context, including immaterial facts, your opinion or state of mind, i.e. non-statements of fact, your current position, and understate your willingness to make concessions or compromise, and your ultimate goals and objectives. You also may be able to exaggerate the strengths and minimize the weaknesses of your factual or legal position, or the value of the subject matter, overstate your confidence in the availability of alternatives, or anything else that you said at the time you did not know was a misrepresentation. For California lawyers, Section 6068, which is also a binding rule, also requires that you employ only those means that are consistent with truth, and you need to look elsewhere for that persuasive and not binding authorities that suggest you can engage in certain misrepresentations in a negotiation, so you need to tread carefully. Setting aside the ethics rules, I believe wise lawyers also will consider the potential consequences of paltering and making misrepresentations in negotiations, in terms of potentially derailing entirely a negotiation that could lead to a deal for your client that is better for him or her than no deal at all. In addition, sharp practice often has reputational consequences, particularly in an industry with many repeat players that you will want to consider before going down that path, not to mention the morality of being a lawyer who lies for a living just because he can get away with it. That is not the type of lawyer that many, and hopefully most, of us want to be, and nothing, not the duty of zealous advocacy or the need to close a big deal, requires us to behave that way. I hope you enjoyed today's program. Thanks for watching.